Strauss. I'm a senior staff lawyer at LEAF, the Women's Legal Education and Action Fund, and I'm joined by Nadia Hasan, assistant professor at the School of Gender, Sexuality, and Women's Studies, as well as the director of the Islamophobia Research Hub at York University. Idil Issa, founder of Femmes Musulmanes contre le racisme et l'islamophobie, FemCore, co-founder of Mouvement Montréal and a law student at the McGill Faculty of Law, and Pearl Eliadis, human rights lawyer, associate professor, professional at McGill's Maxwell School of Public Policy, and a full member of the Center for Human Rights and Legal Pluralism. So thanks so much for being here. We're gonna start with Law 21's impact on Muslim women. The title of the panel is Law 21's Impacts on Muslim Women and the Making of a New Normal. So we're gonna start with the first and gradually move to this discussion of a new normal. So Nadia, you co-authored a report released in 2024 that was already referenced, entitled Social Discord and Second-Class Citizenship, a study of the impact of Bill 21 on Quebec Muslim women in light of the COVID-19 pandemic. It was produced by the National Council for Canadian Muslims. What was the impetus behind producing that report, and what were some of its findings?
Thank you so much for the question, Lee, and thank you for inviting me here, and thank you to everyone involved in making this possible. I know it was a lot of organizing, a lot of planning. I really appreciate the work that's been put into this and creating this space, creating this conversation, and especially somewhere where we can center the impact on Muslim women that I think is often, I guess, stays at the level of informal conversations and anecdote, and hopefully we can add a little bit more color, a little bit more data and evidence to this. If you can't hear me, just raise your hand. I feel like, okay, yeah. I have this problem nearly everywhere I go, so please don't hesitate to let me know. I'll try my best to raise my voice. So as you mentioned, the report was something that I did in collaboration with the National Council of Canadian Muslims, which is a civil liberties and human rights organization, one of the organizations that's combating Bill 21 in court. A big impetus behind the reason we came together to do this is because of Muslim women and the stories we were hearing from women from all sectors, from all backgrounds, of all ages in Quebec, and we really wanted to kind of put our finger on and be able to describe in more specificity what is this trend that we're seeing. So just by way of a bit of background, you all may remember last year, Francois Legault announced his decision to renew the notwithstanding clause. I'm guessing this is like a pretty legally familiar audience, so I'm assuming you all know what that is. But if you remember, when he announced his decision to renew the notwithstanding clause, one of the reasons he gave was because he said Bill 21 had worked, that it was a big success. And it was a success at what? At bringing about social peace, bringing about harmony in Quebec society. I mean, you might also recall that in the lead up to the passage of Bill 21 back in 2019, Legault had proposed the goal of social harmony from the outset. This is what he said was needed in order to bring peace, bring togetherness to Quebec society. But in his words, what he actually said, and this is a translated quote, he said, and I quote, "There are slightly racist people who would like there to be no religious signs anywhere." And then he went on to say, and I quote, "Sometimes you have to give a little to the majority." Within the Muslim community, questions arose about, what exactly do we mean by social peace and social harmony and bringing about social cohesion? Who is it for? Who is going to be at peace through this? And what exactly is he giving away to the majority? And questions arose that, is it our rights that you're giving to the majority in order to bring about this social peace? Since its inception, as many studies have shown, like our study is not the only one, Bill 21 has been steeped in Islamophobic rhetoric where Muslims became both figurative and literal. And I want you to remember that, literal punching bags. Physical violence against Muslims rose after the passage of Bill 21 and during the time it was being debated so hotly at like kind of fever-pitched tones in the media, as well as in the National Assembly. So we decided to kind of embark on this study to start figuring out the real impact on Muslim women. One of my co-authors is in the audience today, Lina Al-Bakr, and Yumna Badawi. I don't think she's here today, but we kind of came together to do this work, to really focus on Muslim women and specifically on their employment, their employability, much of what Safia was talking about right now, about what it means for the future of their livelihoods and their careers, especially 5 years after living under Bill 21. But as the political rhetoric really started escalating and focusing on Muslim women as the law was pushed through the National Assembly, we started hearing more and more stories of Muslim women facing Islamophobic interactions in a variety of ways, from like hate crimes to Muslim women being attacked in public spaces like bus stops. You're just waiting for the bus or you're on the metro and someone physically will attack Muslim women just by being offended at the sight of them. So completely unprovoked attacks, to public harassment, to verbal attacks, to strangers just spitting on Muslim women as they're navigating public spaces. But in addition to this, so these are the kind of hate incidents that we can really understand as Islamophobic, but in addition to this, we also heard stories within employment spaces of Muslim women being asked completely inappropriate questions. Like Sophia gave excellent examples of the kinds of things we found. Questions about their religious practices at job interviews, which is, illegal. Employment being all of a sudden terminated, or of increasingly hostile interactions with their coworkers. And at that point, it was all anecdotal, and so many people had questions about what, how prevalent is this? Like, is this really an impact that we need to really be worried about, or is this just, just a few aberrations from the norm? So we employed a mixed methods approach. We used a survey and interviews, and we were able to get responses from 411 Muslim women from multiple cities in Quebec, as well as interviews with several Muslim women to understand the issues at a deeper and more nuanced level. And much thanks to I think a lot of people in this room are actually part of helping getting those survey responses and aligning those interviews. So thank you to everyone who has been involved in the study. And this is one of the largest studies of Muslim women specifically in Quebec. So what we found was that Muslim women who participated in the study reported increasingly hostile workplaces. So 17% of Muslim women surveyed reported physical aggression at the workplace, and 17% reported physical aggression at the hands of their supervisor. So imagine the power dynamics there. 54% of Muslim women have heard racist or prejudicial remarks, an increase in racist and prejudicial remarks from their colleagues at work. So imagine like your work environment just like transforming in front of your eyes. These are just some of the impacts that we saw in terms of the environment of work. We also saw impacts in career derailment and emigration, which has become a big topic of interest for a lot of people. But we found that 1 in 4 Muslim women surveyed felt that their religion had newly come up in conversations about promotions or career advancement, and they were suspicious that they were denied those opportunities because of those questions. 41% of Muslim women surveyed felt that they were disadvantaged in advancement opportunities due to their religious identity. It's not surprising that, given all of this, 71% of Muslim women we surveyed have considered leaving the province altogether because they're just sick of it. 66% of Muslim women have applied or are considering applying for work within Muslim communities as a result of Bill 21. So a real danger of the community turning more and more inwards, the sort of forced ghettoization of a community that we know leads to nothing good can come out of that. Ironically, also, we found that COVID-19 actually made life a little bit easier. So it gave a little, oddly, it made it difficult in the way that it was difficult for everybody, but it also made it easier because it normalized working from home, not having to interact with people and navigate racial and microaggressions all day. And we also found profound impacts on social and mental well-being. So 64% indicated that Bill 21 had adversely affected their well-being. Many women were just waiting, and we saw the news yesterday, they weren't wrong. They were just waiting for some more of their rights to be taken away. They're just waiting for the government to continue targeting them. And imagine as a woman, as a Muslim woman, as a racialized community, to be up against the state in that way. So what this study shows is that, far, far from creating social peace, as Francois Legault would have you believe, Bill 21 has heightened social discord in this province. It's created a tier of second-class citizenship for those who wear religious symbols, and especially impacts Muslim women in a much, much more intense way. And that is kind of how we came to the title, to really describe that, some of the main claims of why this bill is justified simply don't stand up to the evidence.
Really appreciate that. I'm going to move to Idil. Idil, you have been involved in public life for years as a frequent media commentator who advocates for the rights of marginalized communities, particularly focusing on experiences of racialized Muslim women. As I already said, you ran for city council in 2021 on the Mouvement Montréal ticket, a party that you co-founded. What impact has the law had on you personally?
Mm-hmm. Thank you so much, C. So the law has had a significant impact on me. As a Muslim woman living in Quebec, I came back to Montreal in 2016. I had been working abroad. And already at that time, there had been significant discussion of the place of Muslims in society due to debates around the Charter of Values and conflagrations around, for example, Hérouville. So there was different political touch points that had already happened by the time I came back to Montreal. And I think I had already at that time been writing op-eds from abroad because I was not happy. I was observing what was happening on the political scene abroad, and I was already not happy with what I was seeing. And so when I came back to Montreal, I was involved with a lot of different activist groups at the time. There was an organization called Fondation Parole de Femmes. And so when the Coalition Avenir Québec was elected, they had a majority in the National Assembly. And they had already kind of forecast that they would be implementing Bill 21. In fact, they had said that that would be one of their first projects to introduce. And I like to think I'm good in terms of political strategy. So I knew because they had a simple majority at the National Assembly, they were going to pass it. They had the votes to pass it. So what I was focused on was really trying to change the narrative. Because at that time, François Legault was claiming that there was a consensus. The debate was over. We had gone through the Charte des Valeurs. We had gone through Bill 62. So Charte des Valeurs, Pauline Marois, and Bill 62 was really spearheaded and proposed by the Liberals, the Quebec Liberals. And so the Coalition Avenir wanted to be the party that ended that debate. And so their messaging was really that this debate is over, we have the law that will end this debate. So my challenge was really to upend that narrative in the public discourse. Because up until myself, and not only myself, many people started agitating in civil society. That was the narrative that was really current. So it's not just myself. There's other people, Eve Torres, for example, who was able to really work very heavily with Québec Solidaire to make sure that they publicly came out and said that they were against Bill 21. For myself, I really focused on the FFQ because, as much as I felt like my little nonprofit group was, taking a principled stance, I mean, to be honest, we weren't that important in Quebec society. So I knew that if the Fédération des Femmes du Québec, which is the women's group in Quebec, took a public stance against Bill 21, that would mean something. So I started to agitate. I started to reach out to the head of the FFQ, who at the time was Gabrielle Bouchard. And I have a little informal network of women called Femmes Musulmanes contre le Racisme. And we didn't stuff the ballots, but we came out. We had a heavy presence, let's say, at one of the meetings where there would be votes on this issue. So I made sure that we had a lot of new members to the FFQ. And I made sure we were there on the day where voting was to take place. And I made sure that Gabrielle Bouchard was on side. And of course, Gabrielle was very much on side. It wasn't obvious that would be the case because within the women's movement in Quebec, there's a bit of an old guard and a new guard. So there was a vigorous debate in terms of the old guard feeling that, quite frankly, the hijab was oppressive and a symbol of the oppression of Muslim women, that it was imposed upon us. Whereas a new guard shared my opinion that it was really important to protect the agency of Muslim women and to afford them the respect that they may have made their own mind up about wearing the hijab. So there were many debates. Émilie Nicolas had a presence. And so we were lucky enough to have the FFQ take a public stance against Bill 21. I didn't end there, though. What I did was I actually scooped Gabrielle Bouchard. So she had not known yet that she would be invited to speak at the National Assembly about Bill 21. So the Coalition Avenir Québec was really curating heavily who would appear at the National Assembly because, of course, they wanted to stack it with all sorts of terrible, in my opinion, this is my personal opinion, terrible reactionary feminist groups who would be claiming to speak on behalf of Muslim women and would just completely just railroad our attempts to speak out against Bill 21. So they were really stacking the list of people who would be speaking at the National Assembly during hearings. So I kind of had to get in through a covert way. So through some personal phone calls, a reporter at the Devoir gave me the scoop that the FFQ had been invited. So I called Gabrielle and I said, you've been invited to the National Assembly and you're going to be speaking at the hearings. And she didn't know, so that was good. And then I said, well, you're a nonprofit, you're short-staffed. Let me help you write the report. But you have to give me 5 minutes. So they had been allotted 10 minutes. She gave me 5 of those minutes. And I helped her write the report that the FFQ submitted to the National Assembly on Bill 21. And I put together some testimony of women in the Femmes Musulmanes contre le Racisme to describe how even the debate about Bill 21 was being received. So already, just as Professor Hasan was mentioning, there was already heightened tensions in society. Muslim women walking around, going about their daily business and being confronted in society. So I was able to gather some of that testimony and tell Simon Jolin Barrette to his face that this is what is happening in society and this is why we are against this law. But it was mainly to get it on the record because I knew that the Coalition Avenir Québec had their majority and they would pass this law. So, but during my testimony, I did mention that we would come back in 5, 10, 15 years, and I said that demarcation specifically because I knew that every 5 years, the notwithstanding clause, the use of that had to be renewed. So I knew that this would be a continuing debate within society. And I say all of this to kind of give you a sense at what it really took to galvanize civil society against Bill 21. I mean, initially, even Jagmeet Singh, who wears what in Quebec, what some politicians would call a religious symbol, if you remember back in 2019, he was quite reticent to come out publicly against Bill 21 and to say that he would intervene if it went to the Supreme Court. Because a lot of politicians are afraid of losing votes in Quebec. Quebec is very important for federal leaders in terms of winning elections. You can't really leave out Ontario and you can't really leave out Quebec. So thankfully he's changed positions, but you'll notice, you know, all the leaders, whether it's Justin Trudeau, whether it's Jagmeet Singh, and whether any leader, they're very hesitant with this particular issue. And it's a shame. I just feel that it's a shame that national identity is really being linked to this process of othering. So national identity, it's not really being kind of, it's really linked to othering Muslim women in particular. And I think that's conscious. I think, you know, I wrote an article for the Globe and Mail that Muslim women are an easy target politically. And I just feel that is so unfair, so unfair. And, but, you know, again, all this to say that Muslim women have been active in fighting against Bill 21. We're not sort of this inert or just these victims that have not spoken out against it. You know, there's 200 women in the group, the informal network online. So many of them have been taking interviews, speaking on their own behalf. Many of them are teachers. So while it has been a difficult road, and it's going to continue to be a very long road, you know, not just myself, but many women have been taking an active role.
Thanks so much for all that, Idil. Really appreciate it. I wanted to thank Professor Eliadis for joining us, Pearl for joining us on the panel, and I also wanted to say that this panel was originally going to be more of a bilingual panel, but it's now more of an English panel. But please, during the question and answer session, soyez-vous à l'aise de poser vos questions en français. On est tous capables de répondre en français si vous voulez. Merci. So I want to get to this question that people have raised. You know, Law 21 has worked, and this question of what Law 21 is supposed to do. Because what was interesting to me this year, you know, I'm just gonna flip over to here. Can everybody hear me? Will you raise your hand if you cannot hear me? Great, I'm a pretty loud speaker, so not surprising. So, Law 21, what was this supposed to do? It says in its text, you know, it's aimed at ensuring that parliamentary government and judicial institutes comply with principles of laïcité or secularism in fact and in appearance. But all that it did in practice is regulate what people wear. But this past October, there was a report that came out regarding Bedford Elementary School that I imagine everybody knows about, where teachers were allegedly not teaching sex education or science courses, punishing students with learning disabilities, young girls being told that they were not allowed to play soccer. At first, this was just a report about some teachers who were doing something wrong, but it quickly became a mediatized debate about that was tied to Islam. Premier Legault described the teachers as trying to introduce Islamic religious concepts in a public school. And speaking further about that scandal and another one in another school, St. Maxime High School in Laval, where Muslim students and teachers were praying in school, Bernard Dréville, the education minister, told reporters that the government has a responsibility to look into what could be done to strengthen Bill 21 in relation to Bedford and possibly in relation to other schools in Quebec. But Bill 21 just regulates what people wear. So this leads to the question of what is Bill 21 meant to be doing? I wanted to ask you, Pearl, you've been working at the intersection of human rights, national institutions, and democratic governance for years. You've been based in Quebec while doing that work. I'm wondering first if you could just explain what secularism or laïcité means in Quebec society today, and then what the CAC believes Law 21 should be doing.
So very nice to see everyone here, and it's great to see people have come out in such big numbers. So I'm one of the old guard, or certainly older guard, and come at this from a slightly different perspective, I think, than some folks in the room. So obviously I'm not here as a racialized person, although I want to tell one quick anecdote about that. I was, for the reasons best known to myself, involved in the Bouchard-Taylor Commission in sort of 2008. And I remember sitting around the table in what was supposed to be sort of a sub-legal committee. I'm telling tales out of school on this because I actually think that it's relevant to what's going to come next. And in the context of that sort of legal group, and I think this was actually, in some ways, for me, a better understanding of the beginning of this concept of laïcité and secularism that C was asking about. We were in this room, and I looked around, and this is about multiculturalism or interculturalism. This is about racial diversity. This is about what the new Quebec is going to look like. And everybody in the room was white and French Canadian except me. Everybody. And I was told during that meeting that I was the representative of diversity, which would have been hilarious if it weren't so pathetic. Shortly after that, a random person of color turned up at the meeting, never said a word, we never knew who the person was, had absolutely no input into the proceedings. And when the final report came out, and I appreciate that Professor Taylor subsequently walked back quite a bit of his perspective on certain aspects of that report. When that report came out, one of the things that really struck me in that report was this idea that the de facto majority of the population really had to be given deference. And not only deference, but also acknowledgement in terms of the fears of the loss of their own culture. And that in turn justified the measures that would be taken that ultimately resulted in the Charter of Values and then Bill 21. And now some of you may know that we have recently been presented with Bill 84, which is now going to restrict access to funding for a number of cultural institutions and other aspects that do not comply with Quebec values. And this is all in the same line, in my view. This is all part of a narrative thread around a particularly muscular view of secularism that, in my view, turns the whole concept of secularism on its head. So the Supreme Court said in the Loyola cases and the Saguenay cases that religious freedom and secularism are really flip sides of the same coin, right? If you're going to have a population comprised of people coming from elsewhere, which of course Canada is, you want to make sure that wherever they're coming from, they can exercise or not exercise their faith or not their faith, as they may see fit. And the flip side of that religious freedom, of course, is that the state itself has to be neutral. I don't agree that it's all about what people wear. The opening line about how laïcité is the fundamental value of Quebec society, and we're now seeing it playing out in another dimension in Bill 84. This fundamental idea that it percolates through everything the state does now. It isn't just about what people wear and don't wear. It is an underlying value that has influenced the way in which other legislation is being affected. And I'll give you one other example. Bill 21 also amended and strengthened Bill 62, which nobody in this room has probably heard of, which was the bill that changed the way in which religious accommodations can be granted in the public sector and in some other places too, right? So this idea of reasonable accommodation for religious difference, and you can think about reasonable accommodation for people with disabilities, you can think about reasonable accommodation for women who are pregnant. There's a whole bunch of folks who get the benefit of reasonable accommodation. But in Quebec, the way in which you access reasonable accommodation for religious grounds because of Bill 21 has actually become much more restrictive. It's much harder to get religious accommodation in Quebec, I would argue, than, for example, it is in Ontario. So what has happened, so I have no problem, I should declare myself, we all have our biases. Law is not a neutral exercise. I think secularism is, I think the state must be secular. The state must be secular because people of faith and people of not faith, there's not such a thing, but you know what I mean, are able to express themselves and be themselves and live their best lives only in a state that is neutral vis-a-vis those people. And coming back to your point, and I'll close with this, having a rule that says, yes, well, the problem is that the people who are front-facing the public in their state functions, they have to reflect the neutrality of the state. That's the argument here. It's extending this concept of state neutrality to the people who are representing the state and saying that must translate into the way people present themselves. And in response to that, I would say, who is the problem here? Is it the person who is perceiving the person wearing the religious garment, stereotyping them as being incapable of doing their job? Or is it the person who, by virtue of the fact that they're wearing this, are inherently incapable of doing the job? I mean, obviously it's the first. And the government itself has said this. It's people themselves who are perceiving that these people are unable to do their jobs. And I pleaded for many years before the courts. I had judges who wore kippas. It never once occurred to me, not once, that the person who was going to adjudicate my case was less likely to be competent in doing so because of what they had on their heads, not once. And I find the inherent stereotyping that underpins this idea of the neutrality of the state to be the fundamental problem. The problem isn't secularism. The problem is the way in which secularism is being deployed to oppress people using Section 33 in order to make sure that it escapes judicial scrutiny. And I'm glad that the Supreme Court of Canada has granted leave to appeal, but I think we need to be careful about what we think that's going to mean, especially regarding Section 33 of the Canadian Charter. Thank you.
Thanks so much for that. And we're going to get to discussion of the notwithstanding clause shortly. I just wanted to go back. So we're thinking about the reasons for what the impacts on Muslim women and the kind of stated reasoning behind the law. And we see that the Muslim women are the people who are being most impacted by the law. That was the subject of Nadia's and co-researchers' research. It was the finding at the trial level in the case, in the legal case that's been going on. Law 21 has rooted itself in locating Quebec's desire for secularism in Muslim women's choices. And choices about what to wear. And although it's doing a lot of other things, that's the locus. That has been the locus, and that was the trial judge's finding as well. That it was discussions around women wearing hijabs that was really at the center of the debates and the reasoning for why the government was introducing the bill in the first place. So before we move to the legal aspects of the notwithstanding clause, which I think we all want to talk about, I'm wondering, Nadia, if you could think about what, in your opinion, majority voices in Quebec society, but not just Quebec, it's not just Quebec where this is happening, what majority voices gain from this type of Orientalism, from focusing on Muslim women's clothing as a way to put forward an agenda of Islamophobia, but that's very gendered. It's a gendered form of Islamophobia and a gendered form of secularism.
This was such a great question, and it made me kind of go into a bit of a spiral because there's a lot to talk about here. But just first off, I'm not sure that that the majority of Quebecers really are gaining anything from this law. But I am pretty sure that the CAQ government stands a lot to gain from this law. Mm-hmm. They've used kind of tired old tactics of using the divide and conquer approach, polarizing society, fear-mongering, scapegoating of religious minorities, that's really paid off at the ballot box. And that's where we see the benefits of this law really kind of come to fruition, as it often has throughout society. So this is not, not a genius move by any means. It's a tried and tested way of holding on to power. But it's the form of that power that really kind of, your question really made me think about. What is the form of the power that we're seeing manifest through this law and through the holding on of power of this government? But putting aside that specific context, I think it's also important to remember that when we think about Orientalism, when we think about Orientalist tropes that are used to encapsulate any type of difference, especially when it comes to Muslim communities, this is a framework that was brought to us in 1978 by a Palestinian scholar called Edward Said. And he was grappling with his identity as a Palestinian American within the American Academy. And what he was really trying to do is understand how knowledge production, how the normalization of certain understandings of certain people are produced, and how they actually uphold political projects, how they uphold systems of power, and how they uphold systems of inequity and exclusion and justify them in terms that seem like they're evidence-based and seem like they're really grounded in some kind of sound, rigorous knowledge. And imagine that coming from a Palestinian. Like, imagine what those questions looked like in 1978 when he was trying to figure out what does it mean to be a Palestinian scholar in the American Academy. But there were some key features that he mapped out that I think are important to note. And this was, again, 1978, a long time ago. And you kind of see resonances in how we see Muslim women being talked about now in popular discourse. He talked about the tendency to homogenize, to kind of completely erase the diversity within a group. He talked about the tendency, like kind of related to that, to essentialize, to attribute an essence. So in this case, that Muslim women are oppressed or Muslim women lack agency. Attribute a sense of backwardness or a barrier to progress, that minority communities, that religious minorities or racialized minorities will pose a obstacle for society to progress. And again, you can probably already hear the resonances in the CAC discourse around Muslims, but also rendering them as static, as completely unchanging, that over time they're stuck in the past and will never progress. But most importantly, he talked about how all of this is framed within the colonizer's gaze, that this is never understood on its own terms, and that it's always part of a colonial project. So when you ask how an Orientalist focus really produces this form of gendered Islamophobia and gendered secularism, I think it's important that we're seeing also a manifestation of a colonial patriarchy. Like, we're seeing a manifestation of patriarchal power here that is being enacted on a very specific group of women at the expense of others. But I think also, if you think about, again, as Idil was mentioning, the way Bill 21 was passed, so if you were to take Bill 21 as an example of like how the state produces an Orientalist subject and creates like an Orientalist narrative, you can see that Bill 21 was upheld using the experiences of one or two Muslim or ex-Muslim women to really essentialize what all other Muslim women experience. It relied on depicting Muslim women as unfree and as anti-freedom, as backwards, as against liberation. They talked about Muslim women often without talking to them until there were people like Idil fighting to be heard, right? Fighting. You had to fight to even actually have a say in your own, in things that were impacting your own future and your own lived experience. But also just using Muslim women as rhetorical and political punching bags, making claims about their subjectivity, justifying their oppression as a nationalist project. And this is what both Idil and Pro were talking about, is that there is a overall framing of this as nationalism that I think is particularly terrifying and scary, but also very powerful, and something that we know history has shown us time and time again, how nationalist projects are very successful at enacting this kind of gendered oppression. But what is ultimately gained, I mean, you asked like who's gaining something here, is a consolidation of a racist nationalist project of the state. Ultimately, that is what this law helps uphold. Now, I'll stop there.
If it's all right, we'll move to the discussion of the notwithstanding clause. Idil, are you interested in answering what the notwithstanding clause is? I was going to ask Pearl, but...
I mean, I hesitate to do so with Pearl right beside me. I'm in my last semester of law school.
Okay. Well,
Next semester you'll
yeah.
answer. Yeah.
Pearl, can you please, I'm sure that many people, most people in the room are familiar given how much it's been in the news, but would you please explain what the notwithstanding clause is in the Canadian Charter of Rights and Freedoms and how it was invoked in this case?
Sure, and I'm going to cheat for a second, if I may. I just wanted to respond briefly to this last exchange, if I could. Just to say that so much depends on context and where you are, and how this idea of patriarchy and colonization, the legacy of Said's work, play out. About 10, 15 years ago, I was asked to be part of an academic project that led to a book published in France, and I had to pull out the title because it was a while ago, L'École des femmes et espace genré arabo-musulman. We went to Paris for the conference, and I was the only woman in the room among a lot of Muslim women, Arab and Muslim women, who was advocating for the right of women to wear hijab. And it wasn't because all of those women were colonized. It was because many of those women were taking the position that the pressure placed on them from a community-based perspective and what they had been living in Algeria, Tunisia, wherever it was they were coming from, had meant that they felt that the freedom to not wear hijab was part of a state project that they supported. And as a Quebecer, I have to say, it was a bit of a shock. It was a bit of a shock to be in that space and to be the person who was painted as other in taking that position. I'm not taking a normative position on this, but I'm saying that so much depends on where you are and the experiences of the people around you. And as somebody who is not Muslim and am not speaking for, by, or with those communities, it did require me to sort of step back and think about where I was and who I was talking to and who was in the room. So onto what I was actually asked to talk about. So Section 33, simply put, is a huge Control-Alt-Delete of most of the rights in the Canadian Charter of Rights and Freedoms. It allows a legislature to wave around a magic wand, and there are certain words that need to be used, in order to exempt a statute, and it could be the federal government, it could be provincial government, territorial, municipal, to exempt the law from the scrutiny or oversight or application of certain sections of the Canadian Charter of Rights and Freedoms. And those sections are the fundamental freedoms, expression, thought, religion, association, free, peaceful assembly, life, liberty, and security of the person, unreasonable search and seizure, arrest and detention, legal rights, presumption of innocence, bail, those sorts of things, the right to be free from torture. the equality rights, of course. So there's a range of rights that the minute that magic wand gets waved around in a statute by a government in a certain way, that law is then completely exempt from the Canadian Charter of Rights and Freedoms. The language is very clear, which is part of the reason why I think we need to be careful about being hopeful as I am, that Section 3 will necessarily be, confronted head on by the Supreme Court. It may, and we all may be pleasantly surprised. But I think there's other things that might be going on in that case, and see, you're probably a better place than I am to know what the rest of those are. But at the end of the day, Section 33 is unique in the world. As far as I know, I'm not aware of any other constitution that does quite this. And as I say, operates as simply a huge loophole that a truck can drive through and simply obliterate rights with no conversation and no explanation. This is important, no explanation from the government about why this is necessary. So a lot of the attempts, that were made by jurists, including the former dean of this faculty, Robert Lucky, Mr. Justice Robert Lucky, about to be Mr. Justice Robert Lucky. I'm never sure, is it before or after la sermentation when you actually become real? And I think it's worth pointing out, by the way, we were talking about the impact that this bill has more broadly than Muslim women. I don't know if those of you who read the Francophone press, but the attacks on, I'm going to say Mr. Justice Lucky for the purpose of protocol, the attacks on him recently for having been named judge because of his position against Bill 21 demonstrate to me that the impacts of this law are really starting to spread beyond the intended and original targets. Mm-hmm. So Section 33 is unique, it's deeply problematic. And the last thing I would say about it is when it was first, floating around in the constitutional debates, right? It's a political deal. It's a political deal that's ensconced in a constitution. So Pierre Trudeau, at the time, made a statement. He was asked whether this was going to be a problem. And he said he didn't think so because it would very rarely be used. Mm-hmm. Just like the similar provision in the Canadian Bill of Rights had been very barely used. I mean, the Canadian Bill of Rights itself was very barely used, so that's another problem. But the Charter itself was supposed to be something different, right? And for 25 years or so, this sort of barely used thing prevailed until the Ford government and until the Legault government, and in very different ways. But now we have governments regularly using it as an escape hatch. And one of the interesting things that I noticed in Bill 84, which has just been tabled, is that now what the government is starting to do is realize the backlash that's coming from the use of Section 33, and they're now starting to amend the Quebec Charter of Human Rights and Freedoms, which itself has quasi-constitutional status, to restrict a whole bunch of rights and to introduce these ideas of laïcité, as Bill 21 did, into the Quebec Charter of Rights and Freedoms. In other words, to temper and restrict the idea of rights within the Quebec Charter of Human Rights and Freedoms itself, and therefore they're not even bothering to invoke Section 33 and Bill 84. They're just saying, we're just going to change the Quebec Charter of Human Rights and Freedoms so much that it's really going to become the tool that is going to be used as a rights document to oppress rights. Which should give everybody in this room pause.
Yeah, thanks for that. As a quick follow-up, just could you explain, there is a notwithstanding clause in the Quebec Charter of Human Rights and Freedoms.
I mean, human rights legislation in Canada, so, equality rights statutes, right? The Ontario Human Rights Code, the British Columbia legislation, the Saskatchewan Human Rights Act. Every piece of legislation in Canada that is a statute and an equality rights Act has in it something that says this law will prevail over other laws unless the other law says otherwise. So that's been kind of built into our human rights DNA for a really long time. But what happens when you put it into a charter, I mean, yes, you can say for all intents and purposes it is a notwithstanding clause. The words notwithstanding aren't used in any of the other statutes, but the concept is there. But what's happened is that this little escape hatch, if you will, that exists in human rights statutes across the country and has since 1962, has now graduated and taken on far more significance and power as a constitutional escape hatch. And the way in which we became acclimatized, I think, to this being able to step out happened because originally the idea was that legislatures, you know, for those of you who are lawyers, you know that legislatures can't bind other legislatures in terms of their legislative projects and agendas. So the idea was that, of course, it wasn't a constitution in itself, so of course, you know, statute. But should that apply to a charter? Should that apply to a constitutional document? It seems to me the answer should be different. And the only way I see out of this, frankly, is going to be a communication, which is the UN word for a complaint, to the UN Human Rights Committee on this, because there's no such derogation that's allowed in the ICCPR, the International Covenant on Civil and Political Rights.
Thank you, that's super interesting. Appreciate it. So you mentioned that this is not just happening in Quebec. So I just wanted to, zoom out a little bit, but to think about the ways that it's being framed in Quebec, the use of the notwithstanding clause. The way that the Quebec government is framing it is that it's bringing the will of the people to bear, because it's, the idea of a law being found unconstitutional by virtue of the Charter of Rights and Freedoms. It's a federal law. It's a Canadian Constitution, and we're talking about the Quebec national identity that is being promoted here, and that's why the notwithstanding clause is justified, or one of the reasons. And that argument is also being made in Saskatchewan to justify the use of the notwithstanding clause there. So just to explain, as you all likely know, the government of Saskatchewan in August 2023 created a policy regarding students under the age of 16 who are trans and non-binary, and stated in that policy that in order to have their names and pronouns respected in schools, they would have to get parental consent. When the UR Pride Center for Sexuality and Gender Diversity challenged the policy, they challenged it on the basis of the Canadian Charter of Rights and Freedoms, and a judge hearing the challenge decided to issue an injunction in that case, because he found that because it takes a long time for these cases to be argued. As we know, the Law 21 challenge is only now going to the Supreme Court, when it started in 2020, something like that. And so in the meantime, the judge issued an order that the policy would not be in effect, because otherwise, if it was in effect, it would be causing students irreparable harm. That's part of the legal test. The Saskatchewan government, as you all likely know, went right back, recalled the legislature, and enshrined the policy in law, and invoked the notwithstanding clause in order to do so. Do I have a quote? Yes. So the Premier, Scott Moe, there said, "Our government is extremely dismayed by the judicial overreach of the court blocking implementation of the policy." So he called the injunction judicial overreach, as in the judges are doing more than they should be. They're not doing their job, they're overreaching. And then he said, "This policy has the strong support of a majority of Saskatchewan residents, in particular Saskatchewan parents." So differently, but in Saskatchewan, they are framing their invocation of the notwithstanding clause as preserving the political will of the people against undemocratic judges. So I was wondering, maybe Idil, if you would want to answer, how similar do you think these cases are? And do you think that what's happening in Quebec is part of a larger trend, or do you think it's unique, or both?
Thank you for that, Steve. So I have not been following the case in Saskatchewan closely. In terms of, just to kind of rebound off of what Professor Eliadis had been saying about, different premiers using the notwithstanding clause. From what I understand, and I don't want to start a sidebar on a nerdy sidebar on the notwithstanding clause with Professor Eliadis, but
I'm a nerd, so it's all good. It's all good.
From what I understand, the notwithstanding clause is, some people have kind of been describing it in the media as related to emergency powers, and correct me if I'm wrong, Professor Eliadis, from what I understand, it's more of a political compromise. Am I correct in that?
It was a political deal, but it's not restricted to emergencies.
Yeah, exactly. So that is the thing. So from what I understand, when Pierre Trudeau was successful in bringing over or repatriating the charter, in protest for about 2 years, I believe, in the 1980s, Quebec proactively used the notwithstanding clause.
Yeah, it passed legislation saying that all legislation that's ever existed in Quebec will be notwithstanding, all at the same time. It was ultimately unsuccessful finesse.
Yeah. So I share Professor Eliadis's pessimism in terms of the outcome of court challenges because of the notwithstanding clause. It really is a poison pill in our constitution, and it undermines the charter. And you're right to say that it really doesn't exist in other jurisdictions internationally. So what I fear and what I predict is that the government, the Coalition Avenir Québec, will claim victory and will say that you see Bill 21 is constitutional. That's how they're going to frame it. Whereas it's deeply unconstitutional except for Article 33. So, so that's what we're faced with, and I agree with Pearl that we really have to look beyond Canada for solutions because we can kind of see what's coming down the pipeline. So, with regards to the narrative that this is sort of a new thing that Legault is kind of introducing or Premier Ford, I see a much older genesis, and so I see the poison pill as being at the very at the inception of the repatriation of the charter. So we're going to have to get creative, and in terms of framing the narrative, we're going to have to, prepare for this a potential victory and a potential messaging that Bill 21 is constitutional. And the thing is, how can I phrase this? The way the Coalition Avenir Québec is going about with this nationalist project. So right now it's introducing a constitution. I don't know if you can really have a constitution at the provincial level that's can be, it's more marketing. No?
It's a much longer conversation.
So this nationalist project, in my mind, it's majoritarian, right? It's sort of part of, for me, it belongs in the Italy of Mussolini, right? In a liberal democracy, you do have a balance of power, right? And so the idea that might makes right, and that if the majority wants it, we have to go with it. I mean, we have a carefully crafted constitution, except for Article 33, where minority rights are enshrined. I mean, there's a reason why we have a charter, right? I don't know if Legault is aware of that. There's a reason why. And it's to protect minority rights, and that's because in a democracy where a simple majority can kind of win the day, you do have to have protections for minority rights. So I do think there's certain messaging that's happening, this idea that might makes right, the majority, if the majority wins, then everything's settled. I think that's things we have to predict that are coming down the pipeline.
Thanks for that. I think that it's an interesting way that it's a hard thing for people to wrap their head around because it really is illogical, but the idea that because Section 33 is a part of the Charter, if a government has invoked Section 33 validly, as in if it's done it and followed whatever form it's supposed to, the law, even though it's violating certain rights or could be seen to be violating certain rights, is constitutional because Section 33 is part of the Charter. So it's a double-speak way of living life. As we know, we've been discussing, the Supreme Court granted leave to appeal last week in this challenge, in the Law 21 challenge. I also brought in the Saskatchewan case. That went to the Saskatchewan Court of Appeal in September, and thinking of largely the same questions. What is going on with the notwithstanding clause, and is our courts able to put, actually it's a much more minor question at the Saskatchewan Court of Appeal, but it's still kind of in the broad ways of thinking, like what constraints are there on the notwithstanding clause? I'm wondering if this is really to anybody who's interested in speaking to it, but Nadia, you were involved in the case with NCCM at the beginning,
Early
right?
days,
I believe,
yeah.
and so anyway, anybody who's interested in answering, what, in your opinion, were some of the strongest arguments of the Quebec Court of Appeal regarding why the law should be found unconstitutional despite the notwithstanding clause?
Does everybody know what Section 33 says? Does everybody know? Does anybody not know what it says? Put a hand up. Okay, all right. No shame. So Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or provision thereof, sorry, we say a lot of hereofs and thereofs, and anyway, the point is that it shall operate notwithstanding a provision included in Section 2 or Section 7 to 15, so the ones I set out earlier, of this charter. Control, Alt, Delete. And then there's the sort of 5-year sunset clause. So I think the 3 or 4 arguments that were going to be, it's going to be very interesting to see what the court's going to say. Argument number 1 is that there need to be more guardrails on this. It was pleaded. I'm not sure how a court can do that given the very clear language. But on the other hand, I've been wrong before. So number 1 is more guardrails around the use of Section 33. Number 2 is that there's a bunch of there are several sections of the Canadian Charter of Rights and Freedoms that are not subject to the notwithstanding clause. So they fall outside Control, Alt, Delete. And those sections include things like electoral rights. So there are certain people under Bill 21 who in the electoral process are required to comply with it. The Court of Appeal said that was actually the only part of Bill 21 that was struck down. Now that's been cross-appealed. And by the way, there are 8 separate cases with more than 12 different parties, appeals and cross-appeals, before the Supreme Court of Canada now, as well as, of course, a number of interveners and so on. So it's a complex case. So the second one is the electoral rights. The third one, which I'm watching very carefully because I'm very interested in this intersection between Anglophone and Francophone school boards on the one hand and linguistic rights, and the capacity of English school boards in particular to manage their own school boards and decide who they get to hire, including hijabi women, right? And the Supreme Court of Canada left the door open to that, and the Court of Appeal shut it. And I think that's a live issue with sort of more legs, if you will, than the Section 33 issue. But that's been cross-appealed as well. Then there's the sort of last-ditch creativity that we all start when we're in law school, looking for creative new arguments. But there's the using, for example, sections 27, and I would argue, it's 28, gender equality, and 27, multiculturalism, which are the interpretive provisions of the Charter, right? So what the courts have said is, if you've notwithstanded the rights in the Charter, you can't use interpretive provisions to bootstrap yourself into another right. In other words, you can't say, well, you don't have the right to religion anymore because the notwithstanding clause has been used, but you get to use the interpretive provision which values multiculturalism in order to negate the effects of the notwithstanding clause. The court said you can't do that. It's an interpretation, and interpretation is not a right. Okay, but that's up for grabs, at least as far as the gender equality piece is concerned. And then there's sort of the arguments around pre-Confederation statutes, which are long and tedious. But the idea is that there are sort of some mentions of certain types of religious freedoms that we can now kind of use and take into the kind of modern era. So those I don't think I've missed any big ones, but those are sort of the main areas that are before the court. And this comes back to the question of the will of the people. Like the Supreme Court of Canada never says when it grants leave for appeal, we did it because of this. They never give reasons. And that's a good thing because it gives the court the scope to hear, whatever aspects of the case that it wants. But one of the criteria is that it's a matter of national significance, public interest, public importance, national significance, right? Notwithstanding its majoritarian aspects, right? And again, that's the whole reason why we have a charter. And I'll close with this, which is, and I'm wondering if the court's going to get to this. How bad can it get? How bad can a law be before a court will actually say something in Canada when the notwithstanding clause is used? How far does it have to go? And I think that's an open question right now, because right now I don't think we have a great response to it.
I want to leave some time for questions. I'm sure that people have questions. So I'm going to ask one more question. I don't know if people have a desire. We have two questions we could ask. One is, do we think that Quebecers would accept? What do you think the reception would be of the Supreme Court striking down the laws unconstitutional in Quebec? And I wanted to mention we have info sheets that we made at the front door, and you can get some on your way out that have findings from the report that Nadia co-authored and also from another report. That report was the Association for Canadian Studies. It said that 64.5% of the Quebecers surveyed, they surveyed almost 2,000 people in Quebec, deem it important for the Supreme Court to determine whether Law 21 is discriminatory. And if the courts were to declare the law in violation of the Charter of Rights, support for it would drop significantly. I wonder what people on the panel think of that. Like, because the Supreme Court has struck down laws in Quebec before, and it's not a politically popular thing to be doing. So I wonder what folks on the panel think reception would be here of a Supreme Court judgment.
I don't want to speculate, and I don't want to speak for Quebecers, but I will say that there was, I don't know if you guys would remember the case of Fatima Anbari. Does anyone know this case? This is a teacher in an English school in Chelsea, in Quebec, who's a beautiful person, by the way, just a really great soul. But she was hired and fired while Bill 21 was law, kind of amidst all the confusion and all the legal challenges around especially English schools and their relationship to Bill 21. But after she was fired by the school, she actually went, she had the courage to go public with it. Many people have had this experience, but she was one of the ones who went public with it. She talked about it. She humanized the story, just did an amazing job of bringing the very real lived experience of Bill 21 to the public eye. In that moment, support for Bill 21 in the polls dropped considerably. And it was this moment that I think, I'm not sure if other folks in the room who have been kind of advocating for this for so long, you kind of felt this moment of, if people can see the impact, if people can see what this actually means in real life, like not just as, in theory, social harmony and peace and whatever, then they might change their minds. So I'm hopeful. I'm hopeful, and I think it'll be very telling about what happens next year. And I'm very nervous about the whole thing, but yeah.
So the way I'm looking at it now is, unfortunately, it feels like a loss either way, because unfortunately, from my point of view, the Coalition Avenir Québec has staked its national project on the bodies of Muslim women.
Mm-hmm.
So if they lose, there's people talking about separating, like it's become a national question. And the fact that they framed their national identity and national project on the bodies of Muslim women is just, so now, if Muslim women lose their right, or if it's confirmed by the Supreme Court that they've lost the right to have a position of authority within the government. I mean, it's a loss either way. I mean, I just feel, the next step has to be the UN, because it shouldn't be this way, but the debate around Quebec's identity and future is now framed through this debate and with this debate. A loss at the Supreme Court for the Coalition Avenir Québec would revive separatism, in my point of view. And a win would, of course, reinforce the oppression of Muslim women. And not just Muslim women, also other religious minorities. So it's looking dire, but I do want to say that throughout this battle, what I've tried to do, and interestingly, both allies and enemies, political enemies, have kind of framed Muslim women as victims, whether advocating for them or damaging their rights. But through this entire battle, what I've tried to do is create a place or connections to enable Muslim women to advocate for themselves. 200 women in Femmes Musulmanes contre le Racisme, many of them, for example, Bouchra Shelby, she was on Tout le Monde en Parle speaking to Quebecers about her experience as a teacher. So hopefully people understand that Muslim women are not just victims, that even though this battle is a long one and it's been a very difficult one, that they have been fighting on their own behalves, and they're not just victims in spite of the difficult circumstances.
I just wonder if we could zoom out for a second, because I think this is actually part of something we're seeing globally, which is rise in authoritarianism, rise in right-wing governments, rise in the popularity of measures that equate others with migrants who are therefore damaging society. And we're seeing that with some of the reactions to immigration, migration generally in Quebec. And I think that is layered on top of this fear. And understanding that fear, it seems to me, is really important. Not to justify it, but when you talk to people of goodwill, and there are people of goodwill who support Bill 21, their argument is we have a clear vision for a secular society where everybody is equal and nobody is subject to religious coercion. And that is a perfectly laudable goal, except for that Bill 21 doesn't do any of those things as far as Muslim women are concerned. So I think it's important to keep dialogue up. I think it's important to continue to have these conversations, but the direction comes from the top. And we've seen what's happened with Trump and the impacts on equity, diversity, and inclusion. These conversations are connected. And I don't know if any of you heard, but they were talking about this yesterday, that Trump insinuated that the crash in Washington, right, was the recent crash in Washington was somehow connected to EDI. Like, I don't know whether it was because the pilot of the helicopter was a lesbian, or like the absurdity of these comments is creating a tone from the top that is invalidating concerns around inclusion and giving permission, I think, to extremist discourses that are very damaging, including in this context. And unfortunately, I think CAQ, the CAQ is Coalition Avenir Québec is capitalizing on this, and they're trying to out-PQ the PQ. So, around the sovereigntist debate, there's a real push to try to become, in my view, more extremist. And the only way to deal with that, I think, is going to be, because we're not going to get it from Québec Solidaire, the only way to deal with that, it seems to me right now, the only exit point is a completely revitalized and changed Liberal Party of Quebec. Mm-hmm. And I know this is a thing and not a political thing, but the two are going to end up being connected if we don't have effective, positive, inclusive political leadership.
Thank you so much to all three of you. We have some time for questions. If anybody has any questions, please feel free to